Call court back to order at this time. Mr. Howe, you may begin your argument.
Thank you. May it please the court. Again, Steve Howe, Johnson County District Attorney, making argument on behalf of the appellee in the state of Kansas. I'm going to start out with two issues, or at least one issue broken into two parts that took up most of the brief of the appellant, and that is his self-representation and whether or not Mr. Cross should have been able to represent himself, as well as was he competent to do so. I am not going to go over the facts of the case because those were pretty much set out in both our briefs. So I'm not going to go into a lot of detail, but he did kill William Corcoran, Reed Underwood, and Terry Lamano on that day and put many different people at risk. And we, during our discussion about some of these issues, of course, we'll bring up some of the horrific and vicious nature of these crimes and how it fits within Kansas statute and should have the death penalty upheld in this case. On the self-representation, the lead case on that, which is used on many occasions, is for Ferretta versus California. And Justice Rosen kind of touched on this right at the end before our break, where the court in Ferretta said that the Sixth Amendment does not provide merely that a defense shall be made for the accused. It grants the accused personally the right to make his defense. And I think what I want to touch upon is this is a personal right. This isn't the right that the attorney has, the court system, or the community, but it's a personal right that each and every one of us has. And I think that is the reason why the court granted Mr. Cross his desire to represent himself in this case. Ferretta went on to say that it's the accused, not counsel, who must be informed of the nature and the cause of the accusation, who must be confronted with the witnesses against him, and who must be accorded compulsory process for obtaining witnesses in his favor. The right to defend is given directly to the accused, for it is he who suffers the consequences if the defense fails. And the last thing I want to quote on Ferretta is when they said imposing counsel on the defendant, quote, violates the logic of the Sixth Amendment. In such a case, counsel is not an assistant, but a master, and the right to make a defense is stripped of his personal character upon which the amendment insists. And I would argue that clearly the Sixth Amendment trumps a statutory construction of when a person can or cannot represent themselves. And in Kansas, we do have statutory instruction on when a person can be competent to stand trial and be pro se. This court has addressed these issues before. State v. Vaughn cited in our brief. So this isn't the first time that the court has addressed a pro se defendant representing himself, but this is the first time.
Mr. Howe, can I interrupt you for a second? Is there a distinction between the standard in which we have for competency, which is probably the lowest bar that we have, understand the nature of the charges and assist in your defense, that kind of low bar, and then the ability to represent self? And I think where that hits is Cross's kind of gray area analysis. Would you speak to that? Is there a concern here about that?
Sure. And I know that in the defense brief, they talked about the gray area situation and whether or not he fit under that definition. And I would submit to this court that, in fact, there is no evidence that he is a gray area defendant, that clearly he was competent to stand trial in this case. And there was ample evidence to address that. Indiana versus Edwards, the gray area case that came out, I don't think many people would disagree with the finding that he really wasn't competent to assist in his defense. But this case, if you look at the facts, and I'll kind of go over the facts in this case. First of all, there was a competency report done. In that competency report, they found he was competent to stand trial. There was no indication that he had any history of mental illness, none on the record. And when the defense counsel said that I am asking for a competency report, he said he's doing that out of good faith. And it was mostly based on his behavior and his belief system. But if you also look at how he conducted the crime itself, there's nothing indicating when he committed these crimes that he was not mentally capable. And in fact, if you look at it, he researched his targets. He actually made some, he went out to the Jewish Community Center on multiple occasions to scope out his targets and how he would do it. He bought guns, he practiced shooting. He did all the things that were very methodical. This wasn't an action of an individual who was doing things haphazard, but very strategic and methodical. And I think that's also lends to the fact that this was not a incompetent person, but a competent individual. And then if you look at during the course of the trial, there were multiple motions that he filed. So he didn't just stand on the sidelines when he was granted the permission to be pro se, but filed many motions. Some of the motions granted are not motions that we typically see, but he was doing what he wanted to do. And then if you look during the course of the trial, he actually participated and did things like voir dire, preemptory challenges, opening statement, cross-examination, presenting evidence. He was involved in the instruction conference, and then in the penalty phase, he did opening and closing arguments and presented evidence. And so I think there was nothing in this case to indicate that he was a gray area defendant. And in fact, part of what was said in the appellant brief as well, his racist views on society could be potentially a mental health disorder. Well, the DSM-5 does not recognize that racism is a mental health disorder. In fact, racism is a social construct. It's not a mental health disorder. The other thing, if you look at his actions, I would use the phrase, he's crazy like a fox. And we provided this court ample evidence that he was baiting the judge and myself and my prosecution team throughout the time. And then I think what's really telling is during the trial, we had a recording from the jail call. And I'm going to highlight this because I think it's very compelling to show that he was not a gray area person, but actually an obstructionist. And he indicated, I pick on the DA all the time. You know, he can't stand it. You can tell he's just fuming. Hell, I pick at him, and he can't do a goddamn thing because they don't want a mistrial. That's the last goddamn thing. And then there's a break. That gives me a bit of a license to bullshit and talk shit. And then he went on further about what he was doing with the judge. And he said he was walking the line between being an obstructionist and getting thrown out of court. He quote said, he threatened, quoting Judge Ryan, threatened to put me in another little room with a video camera if I keep disrupting. So I've got to be careful. And we cited to this court a number of cases that said this type of behavior, this obstructionist, intentional conduct, is actually a good indication that he's competent. And he's trying to play games with the court. And if you recall, there are throughout the transcript of the proceedings, as well as the pretrial hearings, the total contempt for the criminal justice system and the United States government. So that played a role in it. And so I would argue to you, Judge, that in fact, there was no evidence of that he was a gray area defendant, and that in fact, he was totally competent and wanted to do, he did what he intended to do throughout these proceedings. And so I think there's ample evidence for this court to find that this is not, there's no competency issue, and that the waiver of his constitutional right, his Sixth Amendment right, was knowingly and intelligently done. And going back to the cases that cite Ferretta, one of the things that they say over and over again, the test is not whether the accused is capable of a good lawyering, but whether he or she knowingly and intelligently waived his or her right to counsel. And that was the Lamar versus State that was quoting Ferretta. So I think that is what we have in this case. And quite frankly, go ahead. I'm sorry.
I didn't mean to interrupt you, and I understand your argument, but can you speak to they don't just limit it to a Sixth Amendment challenge. They also cloak it under the Eighth Amendment and the heightened reliability standard. Can you speak to us whether an Eighth Amendment challenge is appropriate here?
I think that the Eighth Amendment and that there's heightened reliability, I don't believe that is the proper way to address this. I think the proper standard is that clearly in a death penalty case, there's a heightened standard of review. But as far as changing the test, I don't think there's any case law to support the fact that it changes the test or the how we're supposed to analyze it. And so I think in this case, quite frankly, under either scenario, I think there's ample evidence to support the fact that it was a knowing and intelligent waiver of counsel, even if you took the more heightened standard in this case. And I think what's also important, judges, this was a hybrid self-representation, and I want to harken back to that. Let's not forget that on June 17, 2015, there was an in-camera hearing where Judge Ryan provided a lot of support by standby counsel. If you recall, jury selection, that they were going to help with the scoring and the questions to ask, getting witnesses ready to testify on his behalf, lining up the expert, the doctor who actually came in and talked about his health, getting the family and other people arranged to come in to provide testimony. The judge authorized help with the jury instructions, how to make arguments in mitigation. He also allowed them to provide written materials for the defendant. And also the judge granted him the ability to have a friend do some research for his compelled necessity defense. So I think that's also very important in this, and this analysis is that this really was a hybrid self-representation. There wasn't lawyers up there asking questions and making arguments, but behind the scenes, they were doing a lot of what we expect lawyers to do in cases. And so I think that also aids in our analysis that even if you use that heightened reliability, I think we meet that test as well.
In Mr. Cross's brief, it seems like on this issue, he really hones in on the mitigation part of, did Mr. Cross, given who he is, have the ability just for mitigation purposes to present all the evidence that would have helped the jury in mitigation? And I understand your argument that he wanted to represent himself. But when you talk about a hybrid representation, can you speak to whether would it have been possible under the laws of Kansas for, based on my reading of the record, Mr. Cross really had a story that he wanted to get out. Would it have been possible for that story to get out and for counsel to have just in that limited mitigation period presented mitigation evidence? Is that even possible as far as hybrid?
What I would argue to this court is that the case law out there says that when you are granted a right to be pro se and represent yourself, that stays in place unless something drastic happens. And the case law is pretty clear on that issue. And if you look at the cases cited by the appellant, where the courts did intervene and place the lawyers in charge of mitigation, it was only in those situations where the defendant refused to present any mitigation. And I think there's a huge distinction there. And I think if you look at those cases, we don't have anything close to that. We have a situation where the defendant was able to provide pretty much the same type of mitigation he would have had if he had a lawyer. Would he have asked the same questions and maybe gone into the same details? No. But the waiver doesn't say that you don't have to be as good a lawyer in order for it to be a proper waiver. And so if you look at the mitigation defense, it was pretty much provided. And I also want to go back to another in-camera hearing where the defense talked about what mitigation evidence they had, and they started to go over it. And they said, we may have problems getting Mel Gibson and other people that he wanted to come testify on his own behalf. But if you look at the mitigation phase, he went in and talked about what those people believe in, or at least his belief that what those people had like beliefs. And he talked about Mel Gibson and Congress people and David Duke. We didn't object to those hearsay statements. And so all of that came in through hearsay evidence and was presented to the jury as part of the mitigation, part of his compelled necessity defense.
Right, but that was part of the compelled necessity defense. But as Mr. Nelson related during his portion of the argument, things like having his two sons die, that his wife didn't testify, his daughter didn't testify, the obstacles, that he, or I guess the tragic circumstances or the trauma that he has had in his life, that wasn't something that he wanted to present as part of his mitigation theory, but that the lawyers thought would be a good theory of mitigation.
Well, and Justice, I would say this. First of all, I take umbrance with him bringing up the death of his sons and perhaps his background, his life. That was never submitted as part of the record. So
that's what I'm saying, though.
But I don't think that's fair for him to bring that up now. And instead of asserting that, he didn't even insert that in his brief. Then he brings up these details that there's never part of the record. And that's not fair to the state to try to address that. But I would say this. He had his son testify. He had a family friend testify on his behalf. And what he indicated as part of the record is he did not want his pregnant daughter to come testify because he didn't want to put her through that. So he made decisions. And again, this is his case. I go back to the fact that this is his right to have a trial the way he wants the trial. And the lawyers can't tell him what to do. And he made that abundantly clear. And as far as I'm concerned, the Sixth Amendment says, whether it's a good idea or not, you have a right to be your own lawyer. And
but I'm talking more to what Justice Wall was talking about, the heightened reliability that's required by the Eighth Amendment.
Correct. But I would argue to you that even under the heightened reliability, they can't submit what other compelling evidence would have resulted in a different result, right? I mean, so they can't submit any evidence to you that should have been presented that was compelling to the jury that would have changed the results of this case. And I go back to the fact that everything he wanted to talk about, we let him talk about. He went on and on and on. And in fact, when he repeated himself on issues, we didn't object. And so he had the opportunity to present all the mitigation he wanted to present, whether it's compelled necessity, other witnesses, the doctor talking about his health. And so even under that heightened scrutiny, if you choose to use that as the opportunity, there was plenty of evidence to indicate that he got to present the defense he wanted to present. And I think going back to this, are we going to then tell people how they go about doing this? Again, imposing ourselves on his Sixth Amendment right? And I just don't think that's what the law says. Whether we like it or not, he chose this route. This was an intentional act on his part, as you can see from the transcripts. He wanted a certain type of trial, and that is his right under the Constitution. And I think that's the most compelling thing. And whether there's heightened scrutiny or not, he got exactly what he wanted. And isn't that essentially what the Constitution says, that we should not impose ourselves on an individual, but let them make their own decisions? It's no different than in some cases where a defendant pleads guilty and the defense attorney doesn't think that's a good idea. I mean, it's throughout the criminal justice system, people make decisions because they're ultimately the one that has to be held accountable. And so I would argue that taken as in its entirety as a whole, that we would even meet that heightened standard if you choose to impose that upon in this case. The other issues that I would address on the has to do with the fact that we talked about the mental capacity of the individual. Again, if you look at that, I think it also ties in with the instructions. The court denied him the ability to have an instruction because there was no indication that he was mentally disabled in any way. And it was interesting. I'm going to bring up a quote here that when he indicated that he really, even in his own words, he says, it's not because I have a mental health issue. It's because I think he used the term Jew wise, and he wanted that. And so what the court did is, instead of using that instruction, he crafted an instruction that was basically in line with the defendant's beliefs. And so even though he, the instruction 54050 sub 6, even though he didn't meet that standard, the court went above board and gave him his own instruction that was somewhat tied to his compelled necessity defense. And I think that also says a lot about Judge Ryan. He went the extra mile to provide the defendant the opportunity to give his defense. And just going back to Judge Ryan, I would say, as far as the waiver of his right to counsel, I can't imagine a judge doing a better job. I mean, basically, he went down the Barber Handbook, which you have agreed is a really good basis to use on waiver of Sixth Amendment rights, and went line by line, indicating to him and making sure that it was a knowing and intelligent waiver of his right to his Sixth Amendment right. So I think in this case, you couldn't have a better record. The judge made extensive findings. There's like 28 pages of transcripts where he went over and over with the defendant that this was not a good idea, and that the limitations that were going to be imposed upon him. And despite that, the defendant chose that. And he was very clear about that. And it made himself clear for the hearings prior to May 14th that he wanted to represent himself. I'm sorry.
Counsel, was there any indication in the record that defendant Cross was hostile to arguments that standby counsel might have made during the mitigation case?
There was some vague references, Justice, that that both the original lawyer and then the three standby counsel, that he was going against our advice on some of the defenses. So, but there was never any details. I agree that it was just some basic comments that were being made in some of those in-camera hearings, but it didn't go into any extensive details. The last thing I would like to discuss is the comments made by the appellant about the prosecutorial misconduct in closing arguments. And I think what's really important in closing arguments is to hide upon something that many of the justices have already noted, which is that, first of all, the Kansas statute for aggravators was amended in 2011, which broadened the definitions of heinous, atrocious, and cruel, and listed a large number of factors, as well as F7, which any conduct and some of the language there. But what I want to start out with is touching upon, if you look at some of these factors, you will see that the motivation or the actions of the defendant are allowed to be aggravators. And if you look at subsection C, the motive is money, that you're being hired to kill somebody, somebody hires another person to kill somebody. Subsection E, to prevent arrest or prosecution. That's again a motive in the crime. You have under subsection H, killed because the performance of duties as a witness. Again, it's a motive behind the actions that is listed. And then if you go to F and list under F, you see quite a bit of conduct and motive there. Prior stalking under F1, F2, preparation or planning, again, is listed. And then F3, infliction of mental anguish. So the actions and the motive behind the crime is clearly listed throughout the statute. And it is why I think it's appropriate for us to talk about those things, both in the mitigation, or excuse me, in the penalty phase, but also during argument. And then, of course, we have F7, any other conduct the court expressly finds is especially heinous. And it's already been highlighted by this court that not only do we have the pick instruction that gives some definition, but also that an instruction was given that defined the words for the jury. So when counsel for the defendant indicates that it just opens the door and we have opened the Pandora's box to anything, that's not entirely true, because the court is giving the jury direction as to what things they should consider. And then they decide what fits under those definitions. And, you know, that's not any different than we do on all other types of crimes when we give instructions to juries and we give definitions. A good example of that is aggravated battery. We say great bodily harm, and we give a definition of what is great bodily harm, and we let the jury decide, does the facts and the evidence meet that definition? So it's not unheard of that we ask a jury with instructions, with guidance, to make findings. And isn't that the sole purpose of what a jury does? We give them instructions to guide them as to what they should be doing and the basis for their actions, but it's up to the jury to make some decisions on whether or not there's evidence to support. And then the court, as we know, the trial court has the ability to review it as well on post-trial motions, whether or not the verdict is supported by the evidence. And then, as we are right now, the defendant has an opportunity to come before this court and make a decision on whether or not, as a matter of law, whether or not the evidence supports the finding of a sentence of death.
Counsel?
Yes.
Sorry, Justice Miles.
Go ahead.
Do you agree with Mr. Nelson's characterization of the state's argument that the state argued state of mind evidence in support of its aggravating factors?
If state of mind means his belief system and his hatred towards the Jewish people, then yes.
Okay, and so the follow-up question then would be, the defense has argued that that is not legally permissible under the statute because the statute is limited to conduct, and the plain meaning of the word conduct does not encompass worldview, motive, state of mind type evidence. I just would like you to respond to that argument.
Well, but I think if you look at the factors under the aggravators, I think clearly that is not correct, because if you look at how it is structured in the language and the factors, I think intent and motive and his conduct is all captured within those aggravators.
Is the statute ambiguous on this point?
I don't think it is. I think it's pretty clear about what they're saying throughout. I mean, I don't know how more specific you can be than, talking about whether a person hired another individual to kill somebody, and those types of factors.
Well, those. I mean, I'm taking the defense side for a minute here.
Sure.
So to speak. The statute does talk about how the defendant committed the crime. I mean, that's the very first phrase in the statute. And then towards the end, the introductory sentence leading into the 7 examples starts with the word conduct. So I guess I'm asking you to just articulate your position as to what those words actually mean. What did the legislature mean when it talked about how the defendant committed the crime and when the legislature talked about conduct? Is that broad enough to encompass state of mind?
I think conduct would include state of mind and motive. Because, I mean, if you take conduct without piercing in or putting in motive and intent, it really fails to really explain the actions of an individual. I mean, the intent and the motive behind it really explains the conduct of it itself. And so I do think that that was the intent of the legislature. I think that's what the intent of the language is. And then if you look at the list of factors, those factors also are consistent with that type of analysis.
And not trying to put words in your mouth, but would it be correct to say that your argument is essentially from putting this into the analytical framework that we use, that the language chosen by the legislature, by its plain meaning, encompasses state of mind? In other words, as I think I heard you argue, how a defendant committed the crime and the conduct of the crime includes the defendant's state of mind as a matter of plain meaning.
I agree, because if you look at the factors listed below, I think that was their intent. And yet, I think we also need to trust that juries follow the instructions. We presume that juries follow the instructions, and they were given additional instructions about what that means and the parameters of it. And I don't agree with counsel that based on the structure of our statute now, that allows for any type of murder to fit under this. Because first of all, you have to kill more than one individual to be part of the criteria. You also have to fit under the other definitions of the statute. Kansas, I think everyone would agree, is very limited on when you can meet capital murder. It's not like we always joke about Texas, where everybody is eligible for capital murder in Texas versus in Kansas. Kansas is very restrictive. And I do agree that there's a two-step process. First, are you eligible? And then secondly, you go through the analysis of, okay, now let's look at the aggravators and the mitigators, and let's sort out whether or not that person should be sentenced to death. And so I do think that Kansas has constructed this in a way that it's clear what the legislature's intent was, and that things like conduct and intent and motive were all things that they contemplated as being something for the jury to consider and the court to consider during a death penalty case.
Now, if I could kind of hone down on a couple of things there. I think that you are often talking globally about 216624. And I think the defendant is focusing very much just on subsection F. So I would like to do that and start with the fact that we as a principle of law usually strictly when we're dealing with the criminal statute. And typically when we talk about conduct, we're thinking about the actus reus, not the mental state that accompanies the actus reus. Isn't that true?
Justice, I apologize, because as you were talking, my earpiece fell out. So this is part of being in the virtual world.
Yeah.
If you could repeat your question.
I certainly can. I was just saying that, the general principle that we would construe this strictly, and we look at conduct typically in the legal framework of actus reus, not as in the framework of mental state, which is much of what you're talking about. So I start with that premise. And then if you look just at those things that are listed in F, we have stalking or threats, preparation or planning, infliction of mental anguish, torture, continuous acts of violence, and desecration of the body. All of those things to me convey just acts, conduct. So I get back to the question, in that framework, how does F contemplate mental state?
Well, I would argue that prior stalking or criminal threats does go into the issues of motive and his conduct leading up to it. I do also think preparation and planning is also, you could argue that there's some components of that. And so I agree that motive, but I also think motive and intent are hand in hand in many of these instances in the way that they're structuring those. And that clearly in this case under F, it talks about things that are intentional conduct and planning, and I think also motive. And so in a prosecutor's world, when we argue cases before the jury, they're all intertwined with each other. The motive is what drives the individual to do that. And I think if you look at it, and I cited those, if you look at some of the factors under the statute, the legislature intended to have motive play a role in this. And it did it in the other subsections. And I don't think necessarily because F is a separate subsection and has other criteria in it, precludes us from being able to use motive as a driving force as to a basis to be any other conduct. And so I would argue that if you look at the statute in its entirety, throughout all the different subsections, that F should play the same role as the other subsections, which would allow motive, the basis, the intent behind the crime, and just not the crime itself. Hopefully I answered your question.
I think so. Thank you.
I still want to get back to this language from your closing argument about the defendant's belief system being an aggravator. Am I reading that right? You think belief system is an aggravator?
What I was arguing, Judge, is that his belief system, his hatred towards the Jewish people, was the reason why he committed those crimes. So yes, the belief system that he had is belief that under his twisted views that the Jewish people were trying to kill his people, as he coined it, the white people, that was the driving force behind it. So that was part of my analysis. And I was, under F7, I wasn't making any bones about the fact that we were going under the fact that it was a hate crime. And we felt like under F7, that is other type of conduct. And I would argue that if that's not any other conduct, then what would fall under that? Because go ahead.
Let me ask you, what are the boundaries to put on what the state would define as a hate crime that would be an aggravator that qualifies for the death penalty? If we're going to permit hate crime to be an aggravator, which is what you argued to the jury here, your context is hatred of Jews and that Jews didn't deserve to live. But how else do we define it? We've got to create a rule here. And I don't know what the boundaries are. It seems to be quite arbitrary at that point.
Well, I think I agree to a certain extent. What you're saying is that there's some arbitrary nature of that because it says any other conduct. So it does open things up. But I think what's important is, remember, the jury is looking at the evidence that was presented in this case. It's also looking at the definitions of what is heinous, cruel, and atrocious, the instructions given to them about what meets that criteria. And so while the basic premise is maybe very broad, if you look at it in the context in which the case was presented and the definitions that were provided to the jury, I think you can find that it is not so vague that it makes it unfair for the defendant to challenge or refute the actions of the aggravators. And in fact, in this case, there was no bones about the fact that he knew, because he agreed it was a hate crime. He agreed what he did and the reasons why he did it. So there was no dispute or there's no surprise or anything like that. And I think by the bounds of the case as it was presented, gave enough definition that it was not unfair or vague in the sense of how it was presented to the defendant. And the other thing is, under McClin, this court found that you can't just make a generic, it's unconstitutional. You got to somehow say that it's unconstitutional in the context of my case. And if you look at their brief, they really don't make an argument that it's unconstitutional to them. They just make a generic argument that it's unconstitutional on its face. And this court denied that type of argument before. So I think for all those reasons, I think we meet the standards, and then there's enough definition and direction that the jury made a proper finding, and this court can find that the evidence as a matter of law is supported.
Don't you have to, along with what Justice Biles was commenting on, don't you have to tie, I mean, it's just not any extreme belief system that can become an aggravator. Don't you have to show that he was acting on that belief system, and that's what provided the motivation for the crime? Isn't that what kind of ties that in? I mean,
yes.
And so what you have here is, yeah, there's an extreme belief system that he talks about once in front of the jury, but he acted on that belief system, and that's what provided the motivation for him to carry out the criminal acts. And
I agree, Judge. And if I wasn't able to make that argument of the motivation, then it would be a tougher argument to make that it was an aggravator. But in this case, it was truly the motive, the conduct, the motive that drove the conduct that really fit the F7, as any other conduct is especially heinous. And again, if you look at the definitions that were provided as part of the instructions, it gave further direction to the jury. And so I think for all those reasons that it's sufficient as a matter of law.
Let me follow up, because I'm still struggling a little bit, or at least thinking ahead. And I know I appreciate your argument that this defendant doesn't get to raise the hypothetical I'm going to raise. But what happens when someone does a mass killing saying they don't like Democrats or Republicans or people that are Greenpeace? I mean, and they act on it. So they're doing what Justice Rosen's worried about. I'm trying to figure out what the boundaries are for this hate crime that you want to make an aggravator. And again, I appreciate that this defendant may not get to make that argument, but I still want to talk about what the state's doing here in terms of trying to open this door, or this door.
Yeah, and what I would say is that hate crimes have been pretty well defined. I think under federal statute, it's a clear definition is, and so I don't think there would be a willy-nilly application. You know, it's people who don't like cats, you know, or stuff like that. It's just something silly. But I think clearly if you hate somebody because of their beliefs, their own beliefs, or who they are, I think that's a hate crime. And so I think we have to give some faith to the fact that there has to be some basis of law to support a hate crime. I know Kansas doesn't have a hate crime. And one of the reasons why we didn't do it is because, frankly, we felt like under Kansas law, a hate crime can be a departure criteria that could potentially be imposed on other crimes. And in this instance, we argued that it was going to be a case where it's an aggravator, which would represent a basis for the death penalty. But I don't know how to really argue that. I mean, it's almost like, I guess I would go back to what the courts have said about obscenity. When we see it, we know it. It's almost that type of stance where when we see a hate crime, we know it's a hate crime based on the evidence that's presented, and as a matter of law, it's supported by evidence. And so that would be my only argument. It's an interesting concept. I see your point about, do we go too far afield on that? But I don't think in anybody's world that this case is not a hate crime.
Just Mr. Nelson's argument, though, if we know it when we see it, you want to put people to death based on the criteria, and that's the uneasiness that separates this from other crimes.
Well, but then I go back to under McLean, he can't say, well, it could be applied unconstitutionally, so throw out the statute. And this court said, no, you can't do it that way. How is it unconstitutionally applied to you? And clearly in this case, he can't make that argument, or he did not make that argument. And I would submit that it's not proper for review at this point. And even if you did, there's no doubt that it was properly applied in this case.
Well, let's talk about the application in this case and the effect of F7 and the instruction on F7 that any other conduct you expressly find is especially heinous. Why doesn't that just greenlight any juror to find any conduct in evidence in the record sufficient to impose death? What limitation is there at that point in this case?
I would, Justice, I would go back to the instructions that were given to the jury, that they defined some of those words. They gave direction to the jury, and I think that's important. And then also in the evidence in this case, I mean, I think it's important to note that they were asked to consider that because it was a hate crime, that was considered heinous conduct, any other conduct. And then I think, again, if there was a lack of evidence to point the jury towards, or there was a lack of direction, or if I just said you can consider any evidence and those are aggravators and therefore sentence him to death. Well, we didn't do that. We didn't say that you can take any of these factors. What we said is, here are the things that we have met as far as aggravators, and we listed those out, and there was a number of them, as you know. We weren't just writing on the fact that it was a hate crime, but there's a list of other aggravators. And we were very specific about what we were saying that we were asking the jury to consider. So we didn't do the shotgun approach of just throwing everything out there and just saying, consider anything as aggravators. But in fact, we were very specific about it when we told the jury that. And so I think that's a key component of it, is the instructions that were provided, as well as the evidence that was presented, as well as the arguments that were being made.
Yes, and I agree that you did narrow the argument to at least two specific aggravators. But I guess my question is, under the heinous and atrocious aggravator, what conduct in issue in this case would have fallen outside that definition of F7 and that instruction that told the jurors that any other conduct you expressly find is especially heinous, which was defined as wicked or shockingly evil. But what conduct could not have been considered by the jury at that point? I know you limited it to these two aggravators, but my question is, within that aggravator, what conduct is narrowed at that point?
Well, what was argued in the course of the proceedings was, of course, one of the heinous, atrocious, and cruel was the way Terry Lamanno was killed. And despite what counsel said, she did beg for her life. And the court has indicated that type of conduct can be heinous, atrocious, and cruel. And we went over during the jury trial how long she sat there and begged for her life before he shot her. And so that clearly is one of the factors. The second one, of course, is just the actions of him in his hate crime. The fact that, again, the 14-year-old boy, Reed Underwood, his grandfather being shot, and then the gun being pointed at him and him being shot. And I think what's important, and I don't want it to be lost, is the whole motive for him going that day was because there was KC Superstars competition. And the reason why I asked those questions of him was because he knew there were going to be teenagers there. And there would be more, he described there were more Jews, including old Jews, bringing these minors there. And so the reason why I focused on that was part of his motive. And I asked him that question: if you knew Reed Underwood was a 14-year-old Jewish boy, would you have shot him? And he finally admitted he would. And part of the motive and the heinous, cruel, and atrocious is that he's willing to kill anybody of the Jewish faith. And that's part of the essence behind the hate crime, is even a 14-year-old boy would be subject to that. It's just like the Metcalfs, the father and son who he shot at. That was another 14-year-old boy. So it didn't matter your age or anything else. What it mattered was if he thought you were Jewish, he had a license to kill. And so to me, those are the crux behind the F7 and the other heinous, atrocious, and cruel, was the motive and his intent to do harm to anybody that he felt was not one of his people.
Given what you just said and the clear centrality to the state's case for death, to the jury, of the hate crime element, doesn't that suggest that the outcome here on appeal really does turn on the error question? In other words, the state's going to either prevail or not prevail based on whether or not your arguments were error or not. I have a hard time seeing how you can claim harmlessness given the centrality of the hate crime aspect.
I would agree that it's a big part of it. And I won't lie to you and tell you that it's not, because clearly the motive and the way he went about committing those crimes, it was clearly a big part of the case. But I do think that we meet the other criteria as aggravators, and that is...
I'll just interrupt you. You may very well meet the other criteria, but that's not our test on review. Our test is we have to be convinced beyond a reasonable doubt that even if there had been no hate crime argument at all, the outcome would stay the same. And that's really hard to do when the state makes the hate crime such a linchpin of its argument.
Well, I would argue that, let's say we take that out as an aggravator. Let's say that we didn't present that as an aggravator. That evidence would have still came in. And that evidence would have been presented to the jury in this case, because it's part of the case. But we still would have had evidence that he made Terry Lamanno beg for her life before shooting her. We still had multiple people killed, and pretty egregious on its face, even if you take the motive out of it. Killing a grandfather and his grandson in a car, and then shooting at multiple people. So continuous acts of violence after that. Dr. Broadkey, he had a guardian angel. Somehow he didn't get hit with the shotgun blast that went all over past his head. You have him shooting into the Jewish Community Center with his M1 carbine until it jammed. So then he goes to the Village Shalom, where he commits this other act of violence. And so even if you took out F7 and said you shouldn't use that as a factor, that's still overwhelming evidence that there are aggravators that outweigh the mitigators. And I think what's also interesting is, even if we didn't argue that this was a hate crime, it was really clear that evidence was going to come on as far as his compelled necessity defense and his self-representation. So that evidence was coming in, whether we use it as an aggravator or not, but it does help explain the reasons for his conduct, but it also explains the heinous nature of his conduct and what he did that day. And I think I can argue with a straight face here that even if you took the hate crime component out of it, that this was truly a case that was still should be upheld for the death penalty for the other factors that are listed. I think the last thing I would like to touch upon is just in regards to the closing arguments. I would, and to all of your point about hate crimes, we cited State v. Golphin, which I know is a North Carolina case, but it said that racially motivated crimes can be considered heinous, atrocious, and cruel. I would ask that this court find that Kansas agrees with that analysis and finds that a hate crime can be heinous, atrocious, and cruel based on the way our statute is structured. And in closing, I think A lot of you have
Let
indicated.
let me just ask you real quick. Part of Cross's problem with closing argument is that essentially what you did was take his mitigation case and make it one big aggravator. Is that permitted? And how do you distinguish what is rebutting a mitigation case with the concern that he expresses? Or is it even a concern that we should address and be concerned about?
Well, I would argue that you should not be concerned because we followed Clipus 1 and 2 about what you can say in closing argument. I didn't say that his mitigators now become aggravators and they can be a basis for death. I did not argue that. Basically what I was arguing with is his mitigators are pretty weak. And the reason why they're weak is because they're really kind of the nexus behind the reason why he committed those crimes. And I think under Clipus 2 in particular, this court found that those are proper arguments. I don't have to stand silent and say, those are great mitigators and the jury should consider those and give them a lot of weight. I can get up and say, this is why I think those mitigators are weak. And that's what I did in this case. I basically said that these are weak mitigators. And the reason why is because really some of these mitigators are really the nexus or help support the reason why he committed the crime. It's kind of like his health. He said, he made it abundantly clear, the reason he decided to do that day was because he thought, well, I don't have much longer to live and I want to kill Jewish people before I die. And I'm like, well, that was really one of the underlying core motives why he went and did it that day. And so I think I have a right to point out that in the mitigation phase. And I feel like those arguments were consistent with this court's direction in Clipus 2.
But counsel, you actually said that his mitigator was actually an aggravator and actually supports our aggravating circumstances based on his hatred. I mean, I'm looking at the quote out of your closing argument, and you said the mitigator of his belief system and why he acted the way he did, we submit, is actually an aggravator. So you did turn his mitigation case into an aggravation case.
In that one particular instance, yes, where he was talking about his belief system and his hatred to the Jewish people. I think it's proper argument for me to say that's not a mitigator because it's actually an aggravator because it's F7 and it's a hate crime. And so I don't think it's improper for me to make that argument that it's actually incorporated into one of our aggravators. Now, on the other issues, I didn't make that argument, talking about his health. I just talked about that if they were basically weak because they were the nexus behind what drove him that day. But you're correct. I did make that analogy, and I think that's a proper analogy because that was one of our listed aggravators.
Your other questions?
Well, I would thank this court for the opportunity to give oral arguments. Frankly, the death penalty was created for a case like this. I think the legislature structured a limited type of cases to meet this criteria, the worst of the worst, as indicated by counsel. And I think they did this in this case. The actions of Cross that day met the intent of the legislature. He received a fair trial, and the jury made a decision based on the evidence and the law, and he received a death sentence. And I'd ask that this court find that as a matter of law, that the death sentence in this case was legally sufficient and should be upheld, and the death sentence of Frazier Glenn Cross be upheld. And if you have any other questions, I'd be happy to answer them. I'll stand for questions now.
I don't see any further questions. Thank you, Mr. Howe.
Thank you.
Mr. Nelson, you're reserved 10 minutes for rebuttal. You are still muted, sir. Mr. Nelson, you're still muted. We still can't hear you. Still nothing. Mr. Nelson, our technical person is giving you some advice, I think, in the chat room. If you have your chat function open, she may be able to help you.
Let me try.
There you are. Well, I can hear you now. Okay, so.
Small technical challenge.
Yeah, yeah, that's great. So please proceed.
Okay, I'm going to start a little bit from the top on some of the issues that council mentioned. I didn't get to when I gave my presentation, and I'll be pretty quick about those, I hope. I'll just start on the gray area issue that Mr. Cross was competent to stand trial, but not competent to, he was competent to stand trial, certainly, and there's no question about that, but not competent to handle pro se litigation on a life or death capital case because there was bona fide evidence that he had a mental illness that was not resolved by the trial court. Now, counsel points out that there was a competency hearing or a competency evaluation. I'll just comment briefly on that. That competency evaluation was way back in December when he met with an evaluator who relied on Mr. Cross's self-report. Okay, Mr. Cross didn't want to be found incompetent, so he relied on this self-report to find that Mr. Cross was competent to be represented at trial with a team of lawyers. So that did not answer the question about whether he was competent to handle a capital case on his own. But the point being that was also early, months passed before Mr. Cross was finally able to get that Feretta hearing. And in the meantime, the judge had all these letters Mr. Cross was sending about a one world government, about accusing the court of being a high-ranking Mason, about him being an enemy accomplice. Things were beginning to add up. When Mr. Cross met finally and was able to talk to the judge, the first thing that he said was that his two nurses were trying to murder him. This went on and on and on. That ought to have raised red flags all along the way, that by the time the Feretta hearing rolled around, the court should have entertained some kind of bona fide doubt as to whether this man was competent by reason of a mental illness to handle this kind of a case and had him reevaluated. Knowing, I think trial judges often know that mental illness is something that fluctuates back and forth, but certainly red flags have been raised. And I would point out that it could have been halted at any time. His self-representation could have been halted at any time, not only because he was showing these signs of a mental illness, and I'm talking about delusion, and I am talking about a paranoid ideation, everyone out to get him, including everyone in court. So on that basis alone, let alone that counsel keeps saying he was an obstructionist, how on earth is a pro se litigant allowed on the lawyer's side of a bench when they're obstructionist? When he calls the court, first words out of his mouth, an enemy accomplice. Paranoia, yeah. Obstructionist, yes. He may not serve as his own lawyer. Nobody wanted that. The jury didn't want that. This court can't want that.
But don't. That's what he wanted. That's it. Isn't that the issue here? Is that the defendant has a right to represent himself or herself and present the case they want to present? That is the controlling factor that we look at. in both Eighth Amendment and mainly Sixth Amendment analysis. And there was no evidence that he suffered from the mental illness that you're saying was obvious.
Yes, Justice Rosen, I think that a court can consider evidence that the court is looking at and that the court is listening to, and that can give the court a bona fide doubt as to whether the defendant is suffering from paranoia, which he was, or suffering from delusions, which he was, when he believes that after the trial is out, he's fearful that he will be flown to Israel, in which case he will jump out of an open window of the airplane. How is that anything other than a delusional and paranoid belief? That ought to give a judge a reasonable, bona fide doubt as to his competency to proceed as his own attorney, not competence to be found guilty, not competence to be put to death, competency to proceed in the highest stakes case that exists as his own lawyer. So we're just saying that that determination should have been squarely decided by the judge. And we're asking for a remand if Judge Ryan can determine that. If Judge Ryan can make that determination at this late date, that Judge Ryan do that.
Mr. Reed, Mr. Nelson,
Sorry.
will you help me remember? It seems as if, as I was reading through the record, didn't Mr. Cross say on numerous occasions that if he wasn't allowed to represent himself, he would just plead guilty?
Yeah, he said a lot of things. He was interested in pleading guilty and taking life without parole.
If he could not represent himself.
Yeah.
Right. Okay. Thank you.
He did say that, and that was mixed in with his desire to have life without parole. Moving on to the knowing intelligent waiver. A defendant is supposed to know the nature of proceedings before the defendant waives counsel for those proceedings. That is to be given to the defendant at the Feretta waiver hearing when he waives. There was not one word by the judge to Mr. Cross during that waiver Feretta proceeding about the nature of the penalty phase.
I don't have it right in front of me. I have it right to the side of my desk. There was that this is a capital case, the most serious kind of case there is. Death is a consequence. All of that was, I think, disclosed to Mr. Cross, and isn't the essence of a waiver of a right to counsel and to represent yourself more about the pitfalls of self-representation and all the reasons you shouldn't do it, the nature of the case, what stakes are before him or her, and not so much about the knowledge of the legal system. I mean, you're hinging this on that Mr. Cross didn't know all the legalities and what the sophisticated knowledge that it would take to represent yourself in a death penalty case, but that's not what we look for when there's a waiver for self-representation. And that's one of the things, but it's not the main thing. The main thing is, do you know what you're doing here? And do you know what you're putting at stake and what's at risk? And I've read the waiver several times that Judge Ryan did, and I'm pretty clear that that's what happened here, that he understood the pitfalls and what was happening, and that he desired to present the case he wanted to present, and that's what he did.
I would disagree with one thing that you said, Justice Rosen, that he was read the standard waiver that is indicating that it is a poor idea to proceed this way. You're entitled to your lawyers. He was not explained the nature of the case. U.S. Supreme Court required that the nature of the case be explained. That includes charges, that includes defenses. It's not sufficient to say that this is a capital case where you face being put to death. I would argue that's grossly insufficient. And I gave you a recent Oklahoma Court of Appeals case, no stranger to death penalty cases, who said that that was woefully insufficient in that case. And the reason why that it's woefully insufficient not to tell a person who is waiving lawyers, who are the only people who will exercise his constitutional rights at the penalty phase, not to tell that person that there are these aggravators, what they are. Those are the equivalent of charges or mitigators, which are like defenses, is that it is absolutely crucial in all of these cases, and especially this one, that a defendant know what's ahead and understand that there is something to fight for. In other words,
the court apprised him of that, and there's some preface before that, but that if you're convicted, then you go directly to the penalty phase that you face being put to death for this case. How is that not apprising him of what the case is about, or at least in terms that he would understand what the case is about?
Because the defendant has to know that there are two aggravating circumstances that the prosecution must prove beyond a reasonable doubt, just like charges, that there are then mitigating evidence, which can be anything, that the defendant, including mercy, including life without parole, that then the jury can decide based on those that he is not deserving of death, and that in both instances, the aggravating circumstances and proving that those outweigh, they are not outweighed by the mitigating circumstances, that is all the prosecution's burden of proof. That is vital before a defendant waives that, because the defendant, and Mr. Cross said he did feel as though it was more of a formality, and lay people think this, that when somebody is convicted of the capital crime, that it's going to be a formality that they are going to be put to death. And that is why every single juror at voir dire, every single potential juror, and is always by both parties informed thoroughly of the procedures that will occur during the penalty phase of trial. Aggravators, mitigators, weighing, jury is under no obligation to put them to death. The reason why that's so important for jurors is because they have to know what's up ahead, and they have to know if they can do it. If it is that crucial that every case this court will ever see, that all potential jurors understand the proceedings of the death penalty case, how much more important is it that before a defendant waives his right to counsel, who will really be the thing standing in the way of a death penalty, that person understand and know what those procedures are, and not even thorough. I'm just talking about the basic equivalent of charges, defenses, and how that balancing works. So this was not explained to him. He did not knowingly waive the penalty phase of this trial. On the as far as what kind of mitigation, I think my colleague opposing counsel indicated that maybe the same mitigation would have been provided had he been represented. No. And he did talk about his deceased sons. He specifically in penalty phase talked about his deceased sons. I think that there was a misprint where the court reporter maybe said 3, but then he said Michael and the other one are up in heaven. You know, those are the tragedies. No exploration of childhood, one sentence. No explanation of how these views were passed on to him. We have free will, but it is more complicated. Defense attorneys would have spelled that out. You know, no indication of his problems with depression. The other things that he suffers, it is through suffering that the jury takes the full measure of a defendant who is fighting for their life, and they were not able to take the full measure. He get what he wanted. I think I heard that comment. He got what the kind of trial he wanted. He didn't get the kind of trial that society wants. He didn't get the trial that jurors who are under the obligation to make a reasoned, moral response. It's not the kind of trial that they wanted. And this court is charged with looking at this trial for any arbitrary factor. It's not the kind of trial that this court wants to review. These trials must be fair and must appear fair to all who observe them. That's the US Supreme Court. This one wasn't. Mr. Cross, let me get this straight. Mr. Cross, at the time of the trial, 74-year-old man, clearly unbalanced, in a wheelchair, hard of hearing it in this trial, in a fight for his life, and he was prohibited from talking with counsel. They sat behind him. They were not allowed at a certain point to discuss the case with him unless it was outside. Prosecutor objected when he tried in the penalty phase on the legal argument about the mitigation case coming in. So no, he wasn't assisted by standby counsel. It was not hybrid at all. So that 74-year-old man in a trial for his life against two of the most highly seasoned, I assume, and I believe, prosecutors in the DA's office. No, he was not presented the kind of mitigation case that should have been presented. And since there was so much discussion about motive, where does that end? Where does motive end? Hate crime, legislature could have put that in. They know what a hate crime is. They didn't. But motive, so there's always motive. If someone, first degree murder case, after 10 years, kills their spouse, cold-blooded, motive, he bided his time. I mean, prosecutors are quite talented and competitive. That person bided their time for 10 years, shot this person in cold blood. If motive is allowed, why isn't it going to be argued as a basis for death in every single premeditated murder case? I understand this is an extreme case, but if there are no limits set, then everything's open.
Counsel, just taking a simple example under F7, stalking is an action. But every time someone follows someone around many times, it's not necessarily stalking. They might be on their way to work. It doesn't have the same feel to it. And yet it's the same action. So doesn't it provide context what's in the person's mind who is doing that action?
Yes. Yes.
So isn't that needed when you're contemplating and analyzing the actions that are described in F7?
Your Honor, if I remember correctly, the Kleypas court dealt with this exact type of question in terms of stalking, and they tied it to conduct. They tied it to, it's supposed to be a victim-centered aggravator, and they tied it to, it's relevant if it can show that the victim was under more terror, mental anguish during the time of the murder.
May I ask a different question, Mr. Nelson, just very quickly on Mr. Cross's issue number 7? I just wondered on the statutory definition of heinous, atrocious, or cruel as an aggravating factor, and you've said that it's unconstitutionally vague. Are you saying that facially or as applied? Because I know your next issue talks about closing argument with, and that's obviously applied, closing argument and how subsection F was used there. But on your issue number 7, is that just facial or as applied?
It is both, Your Honor. It is absolutely unconstitutional provision because it opens it up. So it is facially invalid, absolutely facially invalid, and it's invalid as applied because the prosecutor returned to it over and over again. I think discussed that exact provision at least 3 times. And as I say, went beyond it because the prosecution opened it up to anything. They changed the statute from any conduct, which at least limited it. The legislature had a hope and desire that that would at least be limited to conduct. But in closing arguments, the prosecutor used that provision and went beyond it and said anything. So But even if they hadn't, they referenced that 3 times and used it to pull in all of their hate crime, the age, all the things that they felt like warranted the death penalty. So both as applied and on its face.
There are other questions? Mr. Nelson, if you'd like to summarize quickly, we give you a chance.
Okay, Mr. Cross was entitled to a jury verdict that was not tainted by the prosecution's inflammatory comments in closing argument, which were very inflammatory and were outside the statute, and frankly, were some of the most disturbing aspects of the case. So they would have been paid attention to and influenced the jury. He was entitled to a statute that's constitutional instead of injecting the arbitrary idea that any conduct the jury decides, which is a first-degree premeditated murder for some jurors, in and of itself is heinous, especially heinous. And I would encourage this court not to act as kind of super jurors in a harmless error analysis, to where it is the jury that, by reason solely of mercy and by reason solely that life without parole is a harsh and just punishment where someone will die in prison, that decision and that balancing should be weighed by a jury. And I would say rather than this court in this case. And that jury verdict was tainted. Thank you, Your Honor.
Thank you to both counsel for your arguments this morning. We will be in recess until 1:30 this afternoon, when we will resume arguments on this case, the remaining issue.